Katya Bigman. I'm a 2022 Coolidge Senator and a student at Stanford University. We will now move to session 4. The title of this session is 20th Century Battles Over the Declaration. The moderator of this session will be Ambassador Richard Graber, President and Chief Executive of the Lynd and Harry Bradley Foundation. Mr. Graber previously served as the United States Ambassador to the Czech Republic. Please join me in welcoming Ambassador Graber and our panelists to the stage.
Well, thank you very much, and good afternoon. We have, some might think, a little bit of a downer of a topic, at least to some of you in this room. We're going to do our very best to stay upbeat through the whole thing, I promise. Progressivism started really as a marginal 19th century movement, mostly at the state level. The problems the progressives identified were truly real enough. Trouble on farms, poor conditions at factories. And the progressives argued that in a new industrial age, only a modern progressive philosophy could possibly work in America. It was time for modern redistribution of wealth and modern science applied in Washington, D.C. to improve our standard of living. Everything else was just outdated. But the way the progressives sought to solve such challenges by radically expanding government into American lives proved just a bit too radical for many. Americans saw that the progressive emphasis on revolt and class warfare simply didn't square with the text of our founding documents, of course, the Declaration and the Constitution. For progressivism to become mainstream and to legitimize it, the progressives pushed for a reinterpretation of the documents of the American Revolution. And sadly, that reinterpretation took place. Indeed, by the end of the 20th century, progressivism had become the default philosophy for our country, whether it be in Washington, in our nation's schools, or in the media. The one area where default progressivism has been successfully challenged is in the courts, and we'll talk about that a bit later. To explain how this rather stunning 20th century transformation occurred is the work of our panel this afternoon. We'll start through Judge Jones, which, with shifts that took place early on at the turn of the century at law schools and in the legal culture. To showcase the application of the new progressivism in the executive branch, our second panelist, Christopher Cox, will present a character study of President Woodrow Wilson. It was, as Amity Schlaze noted over lunch, the unconstitutionality of Wilsonian progressivism that Coolidge sought to highlight when he delivered his stunning speech in 1926, the inspiration of the Declaration, which we've talked about throughout the day. Coolidge successfully slowed that first progressive wave, but not those that followed. Judge Chad Radler will turn to the second and third progressive waves. We have a big task for Chad: the New Deal of the 1930s and the Great Society of the 1960s, and legal cases from those periods that locked in these disturbing changes to national philosophy. That locking in, not only in the courts, but also in schools and politics, will be the subject of our final panelist, Professor Brad Watson. This is a really qualified panel, outstanding group, as you'll see from your program. As I alluded at the outset, I suppose it could also be called a tragic panel, except for the fact that a few of our leaders, including Coolidge, have tried very hard to return to our original principles and in fact have gained some traction. The shift in our courts from the time of Justice Scalia and his originalism has been genuine. That can't be disputed. Sometimes, as under President Ronald Reagan, for instance, shifts in our political leadership have also helped to push back statutory progressivism. I'll change it up a little bit. I'll introduce each speaker just before their remarks, and then, of course, ask them to speak for 10 minutes. And as with the other panels, we'll have time for questions and answers. Now our panel. Our first speaker, Judge Edith Holland Jones, sits on the U.S. Court of Appeals for the Fifth Circuit. She was appointed to the court in 1985 by President Ronald Reagan and served as Chief Judge from 2006 to 2012. Today she'll speak to us about the judicial origins of progressivism. Judge.
Thank you, sir. I'm very pleased to be here. I'm going to go a little bit different from the judicial origins of progressivism, because I assumed Professor Watson was going to be much more up to that task than I, but I would like to talk about describing the effect of progressivism, a time when the Supreme Court had enforced property rights according to the Declaration, and that was a window of time from approximately 1880 to 1920. And I'll be happy to answer other questions about judicial origins during the question period. I hope you have all heard enough earlier today to persuade you that the framers did have a very strong belief that freedom is intimately connected not just with inherent rights to free speech and religion and rights against the government in criminal prosecution and so on, but also the rights to acquire, use, and exchange property. And that is, although I understand what Professor Allen was saying, I've always been persuaded that property rights are part of what was spoken about in the Declaration. But I'm not the only one who did, as I'll show you in a minute. So let us take as a starting assumption that the Declaration was intended to protect property rights, and we know that various provisions of the Constitution were intended to do that also. But at the same time, property rights were never held to be inviolable by government. Under English common law and natural principles of jurisprudence, governments could impose a number of reasonable regulations on contracts and trade. They had routinely prohibited contracts procured by fraud or duress, contracts by minors, illegal contracts, contracts in restraint of trade. In some instances, historically, the courts had, or rather legislatures, had imposed price fixing on businesses of a particular kind, those affected with a public interest. And then as time went on, there was this general rubric of legislative empowerment called the police power, which allowed the legislature to make laws to protect public health, safety, and morals. In the latter part of the 19th century, as we know, the progressive movement arose and had an enormous impact on legislation and the political era of the time. I won't describe the progressive movement to you now. I'll defer that to Professor Watson, but I will add that Woodrow Wilson was one of the important contributors to the ideological basis for the progressive movement, and in that capacity, when he became president, he dramatically expanded the reach of what we now call the administrative state, because an essential part of the progressive philosophy was to supplant local government with government by allegedly disinterested, dispassionate administrators who would operate on the basis of science and technology rather than adhere to transcendent and immanent principles. So we had this progressive philosophy evolving in the political and social sphere at the same time, and ginning up a lot of regulations on business that hadn't existed before. Well, parallel with that, we had a Supreme Court approximately from the late 1870s to the 1920s, who had been trained in the law much the way that Calvin Coolidge was. And that is to say, for most of the 19th century, lawyers trained under Blackstone, who, as you saw, was an exponent of natural law principles and the common law. They had read Justice Story, they had read Kent's commentaries. They very much believed in the Declaration of Independence. And therefore, in the 1897 opinion of the court for unanimous court in Allgaier v. Louisiana, they quoted a concurrence from an earlier case and held as a principle of constitutional law, the right to follow any of the common occupations of life is an inalienable right. It was formulated as such under the phrase pursuit of happiness in the Declaration of Independence. They then quoted the famous Justice Harlan's statement, also for unanimous court, that the court acknowledged the proposition that the equal enjoyment of pursuing an ordinary calling or trade and of acquiring, holding, and selling property is an essential part of a person's rights of liberty and property as guaranteed by the 14th Amendment. So Allgaier established a constitutional due process right to follow the ordinary callings, which in subsequent cases became the right to freely enter contracts. So let's go, this court, which is now roundly condemned in every law school as the advocates of substantive due process, the advocates of the right of contract, which appears nowhere in the Constitution per se, although it did appear in the series of these cases. This court also upheld a number of regulations, many of them of progressive origin. I don't have time to go into them in my 3 more minutes, but it is unfair to condemn that court without actually looking at its reasoning. It's unfair to condemn any court decision without, just on the basis of the result, you have to look carefully at the reasoning. So I move to the infamous case Lochner versus New York, 1905. The Supreme Court overturned a state law that prescribed a maximum 10 hours a day, 60 hours a week, employment for bakers and confectioners. Joseph Lochner, the immigrant proprietor of a small bakery in Utica, New York, was sentenced to jail until and unless he paid a $50 fine. $50 bought a lot more than a hamburger in those days. He appealed the conviction unsuccessfully, and the Supreme Court took it up. The court quoted the general right from Allgaier, part of the liberty of the individual, protected by the 14th Amendment of the Federal Constitution. Now, what's significant here for present limited purposes is 8 members of the Supreme Court still agreed with that proposition. The dissenter from that proposition was Oliver Wendell Holmes. Oliver Wendell Holmes rejected the idea that courts should set any limit on a right to contract under the 14th Amendment. More than that, Holmes was not a progressive. He was a moral skeptic. He was one of the intellectual founders, so to speak, of legal realism. He had the famous quote, he was great with aphorisms, maybe not as great in sound legal analysis, but that's another story. He wrote in his dissent, the 14th Amendment does not enact Mr. Herbert Spencer's social statics. The Constitution does not embody a particular economic theory, whether of paternalism in the organic relation of the citizen to the state or of laissez-faire. Holmes therefore staked out a position from his position of skepticism that any law that the legislatures pass has to be constitutional unless it is so utterly irrational that it cannot possibly be justified. Well, this kind of skepticism has consequences. Later, he wrote the odious opinion, Buck v. Bell, which upheld a regulation from Virginia that had required the forced sterilization of the mentally retarded. So when you pursue this idea of complete abdication of judicial rights, you do lead to the unbridled, unbounded right of majoritarianism. Now, there's constantly been a tension in constitutional adjudication between the limited role that the judiciary is supposed to hold in our government, a role with which I normally fully agree, and the rights of the people to govern themselves through their legislatures. But what happened with the rejection of Lochner, and I would love to talk about Atkins v. Children's Hospital later, if I have the chance, is that the court, later on, in overturning both of those decisions, utterly forswore, basically, substantive review of any economic legislation that occurs. Well, as you see, was that intended in the Constitution? Absolutely not. Was it intended in the declarations, statements of life, liberty, and the pursuit of happiness? Absolutely not. And so, while I do not propose that judges at this point in time go back fully to the 1880s, it is a very interesting thought experiment to consider where would American free enterprise have gone had there been a modest and reasoned judicial approach to economic regulation under the Constitution, regulations preventing the wholesale unbridled interference that leads to the situation in which we routinely find ourselves today. And I hope someone will ask me further questions. Thank you.
Thanks, Judge. Our second speaker is Christopher Cox. Chris is a public servant of enormous experience, serving as Senior Associate Counsel to President Reagan, Chairman of the Homeland Security Committee in the United States House of Representatives, Chairman of the U.S. Securities and Exchange Commission. Amazing. Chris has spent more than a decade researching Woodrow Wilson for his new book, Woodrow Wilson, The Light Withdrawn. Chris.
Well, thank you. You warned everyone that this panel could be a downer. The best I can say for the tale that I'm about to spin about Woodrow Wilson's role in the milieu that we've been describing is that it brings to mind Mark Twain's comment about Richard Wagner's music. It's not as bad as it sounds. I think no American president in the 20th century devoted more of his life and his career to thinking about politics in the abstract than Woodrow Wilson. As a professor at Princeton University, Wilson declared that democracy does not mean the people are truly sovereign. There must be rule, and there must be rulers, command and obedience, authority and submission to authority. In this speech, which he gave repeatedly to paying audiences throughout the 1890s, Wilson spoke of the people 37 times. But for him, the people did not mean women, only men, and not all men, but white men. It certainly did not include black men, at least not in the South where he had grown up and become firmly opposed to allowing the people that he derided as ignorant Negroes to cast a ballot. Men meant the white men that he called in his book, The State, Aryans, and particularly those of Anglo-Saxon stock. So he wrote in his textbook. Wilson the academic and Wilson the president brought these ideas to his interpretation of the Declaration of Independence. In a 4th of July address during his second year in the White House, he asked his audience, have you ever read the Declaration of Independence with close comprehension? He wanted to know if they had focused on the real character of it. That, he said, was not to be found in the famous preamble setting forth its purpose. Instead, he lectured, the discerning reader would pass beyond these preliminary passages because the famous quote about the rights of men was not the heart of the document. It was a theme Wilson hammered on throughout his academic years. The Declaration, quote, does indeed open with the assertion that all men are equal. He acknowledged in a 1907 speech, and he repeated this in a magazine article. But he maintained that Mr. Jefferson and his colleagues in the Continental Congress spoke for no generation but their own. We in modern times, he said, are not bound to adhere to the doctrines held by the signers of the Declaration of Independence. Every generation should determine afresh what principles we think most likely to affect our safety and happiness. He'd been especially blunt in saying so during his first campaign for president. He was speaking in Los Angeles to the Jefferson Club. And he urged his audience, who, by the way, were about to go to the polls in 1911 to decide under state law whether women should be able to cast a vote. And he claimed in this address that the Declaration is better understood if one simply excises the first two paragraphs, those setting forth the idea that all men are created equal and endowed by their Creator with certain unalienable rights. These words are mere verbiage, he told the members of the Jefferson Club. They comprise merely a rhetorical introduction. They are the least part of it. If you want to understand the real Declaration of Independence, he concluded, do not repeat the preface. After decades of teaching government, Wilson, a seasoned academic, knew that he was not making an original argument. Trivializing the Declaration's opening words had long been a staple of Southern Democratic rationalizations for denying voting rights to black people. It was, of course, an explicit basis for the Dred Scott decision issued shortly after Wilson was born in Virginia. Wilson, of course, was himself a son of the South, born in Virginia, raised in Georgia, South Carolina, and North Carolina. He was deeply influenced by the experience of the Civil War in his youth and then Reconstruction. And he was not only familiar with these arguments made by white Southern Democrats, men, but he advanced them himself. In his History of the American People, published in the year he became president of Princeton, he maintained that, quote, giving the Negro political power in order that he might defend his own rights had paved the way for the ruin of the South. Wilson's dismissal of the Declaration's preamble echoed Chief Justice Roger Taney's majority opinion in the Dred Scott case, though by the time Wilson was writing in the second decade of the 20th century, that case had long since become a dead letter thanks to the Reconstruction amendments to the Constitution. In that notorious decision, you may recall, Taney acknowledged that the general words of the preamble would seem to embrace the whole human family, but he then faulted the Declaration for not describing with specificity who shall be regarded as one of the people. So the Dred Scott Court corrected this flaw in the Declaration by deciding a priori that black men and women are, quote, beings of an inferior order. Wilson, the historian, surely knew of Abraham Lincoln's instant rebuttal to the Taney Court's argument. Lincoln condemned the case and the opinion for doing obvious violence to the plain, unmistakable language of the Declaration. The authors of that notable instrument, Lincoln explained, intended to include all men, not because they thought all men equal in all respects. They didn't mean to say all were equal in color, size, intellect, moral developments, or social capacity, but they clearly expressed the ways in which they did consider all men are created equal. The Declaration asserts they are equal in certain inalienable rights, among which are life, liberty, and the pursuit of happiness. This they said, and this they meant. That was Lincoln's conclusion. Those words of Lincoln's echoed Frederick Douglass, who in 1852 affirmed that the signers of the Declaration of Independence, quote, meant that justice, liberty, and humanity were final. And a half century later, Calvin Coolidge underscored the point when he famously declared, if all men are created equal, that is final. So this question of who are the people and who are beings of an inferior order had very practical application in Wilson's time when it came to deciding who should be allowed to vote. Throughout most of his career, Wilson opposed admitting women to the ranks of those citizens who could cast a vote. He categorically opposed women voting when he was governor of New Jersey. When he was campaigning for president, he tried not to talk about it at all, but privately continued to express his view that women voting was a terrible idea. He was, however, shamed by some of the Democrats in the 20th century who did not like the idea that members of their party were not on board with the plain meaning of the Declaration of Independence. Speaking in Congress less than a year after Wilson's address to the Jefferson Club, a Democratic representative from Colorado, Edward Taylor, made a speech on the House floor directly attacking that view. "Let us show to the world," he said, "that we believe in the Declaration of Independence." And he shamed those like Wilson who argued that men and women are not equally possessed of unalienable rights. So that's the part that's not so bad. There are other people that are pushing on Wilson. For Wilson as president, giving short shrift to the Declaration's notion of equality under law had serious consequences. When he campaigned in 1912, he ran against Teddy Roosevelt, who was banging the drum for the Susan B. Anthony Amendment, which would give women across the country the right to vote. When he ran for president in 1916, he was facing Republican Charles Evans Hughes, who likewise was a supporter of the Anthony Amendment. On both occasions, Wilson stood staunchly opposed. In that 1916 contest, Wilson confessed in a private meeting with Democratic women that the states' rights argument that he had been consistently using to explain his opposition to the Anthony Amendment was really a dodge, it was a ruse. One of the women in that meeting, Harriet Stanton Blatch, who was the daughter of the famous suffragist Elizabeth Cady Stanton, had asked him point blank whether he would support the Anthony Amendment. He said he would not. And he told the women, "Dismiss from your minds the idea that my party or I are concerned about states' rights. It is the Negro question, Mrs. Blatch, that keeps my party from doing as you wish." The Anthony Amendment, were it to be successful, would authorize explicitly in its Section 2 federal enforcement of voting rights across the country, including in the South, and that would be a direct threat to Jim Crow and therefore to democratic rule in the South. It was Wilson's fundamental conviction that the white men of the South, and he put this in writing, should not, and published it. I mean, this is not some private thought of his, should not be subjected to the rule of black people. Almost immediately after taking office, he, of course, notoriously introduced segregation across the federal government. 3 years ago, in 2021, the National Bureau of Economic Research did a survey of the civil service records during the Wilson administration and verified that that segregation permeated the entire federal workforce. Wilson patronizingly explained to those who complained when they met with him in the White House that segregation is in the best interest of both races in order to overcome friction. Wilson very reluctantly got on board with the Anthony Amendment late in his presidency, the night before 2/3 of the House of Representatives was scheduled to vote 2/3 in favor of this amendment. And in fact, according to the accounts that Wilson received the night before from a dozen Democrats who visited him, they needed him to say something because he had not in support, because it was going to pass by a dozen votes, and to have the leader of their party sitting on the sidelines would not reflect well on the Democratic Party. So in the most limited way, he agreed to endorse the Anthony Amendment. He would not put out a statement of his own. He ghost wrote a sentence, one sentence, that he allowed the members of Congress to put out that said they'd asked him, and he said he would be in favor. He then said nothing about it for 9 more months until the Senate voted on it. And then again, at the very last moment, he made his first public speech in favor, and that was a very fine speech in favor of women's right to vote. He finally was on board, and one would think now the Declaration has been vindicated. But almost immediately afterward, when the Senate narrowly failed to pass the Anthony Amendment, he agreed with Southern Democrats to change the wording of the Susan B. Anthony Amendment to eliminate federal enforcement so that the Southern Democrats who supported Jim Crow could get on board with it. It was a last-ditch effort in the closing days of the Democratic Congress in the lame duck. They tried desperately in the House and Senate to ram it through. Fortunately for posterity, that did not happen. And when the Republican Congress finally came to town after Wilson called them into session in May of 1919, took them 3 days in the House to pass the unadulterated Anthony Amendment, and the Senate followed as rapidly as the Senate can, and women in 1920 got a chance to vote. I will say that not all of them did, and that is because Jim Crow continued in the South, as we well know, for decades. That's the unhappy part of the story, but the happy part of the story is that Congress pressed Wilson hard enough that he eventually had to knuckle under, and eventually the amendment that made it into the Constitution had nothing to do with protecting Jim Crow.
Great. Thank you. Thanks, Chris. Our third speaker is Judge Chad Radler. Judge Radler served as acting Assistant Attorney General for the Civil Division of the United States Department of Justice from 2017 to 2019, after which he was confirmed to serve as Circuit Judge on the Sixth Circuit. Today, Judge Radler will speak to us about later developments in progressive jurisprudence, especially after the administrative state started growing explosively during the New Deal and, of course, the Great Society. Judge, your turn.
Great, thank you, Ambassador. It's great to be back with the Coolidge Foundation and especially the student scholars. As you heard, I'm a lawyer and judge serving on the Sixth Circuit Court of Appeals, which encompasses 4 states in the great heartland of America: Kentucky, Michigan, Ohio, and Tennessee. Now, none will recognize colonies at the time of the signing of the Declaration, but since our topic today is the 20th century, I have to mention that all 4 states were great contributors to American growth over the course of that century, especially my home state of Michigan, where I grew up, and my current state, where I lived most of my professional career, Ohio. Now, to me, it's important to point out that, like other judges, I'm neither a professional historian nor a political scientist. And those realities are things we must keep in mind in performing our judicial duties. So looking back at the Declaration, I feel best equipped to assess the legal developments that have helped shape its arc. And all too often, regrettably, the Supreme Court, or those seeking to influence it, have fallen short in honoring foundational themes in the Declaration. Let me share 3 examples from the 20th century that demonstrate the point. At its core, the Declaration prioritized individual liberty. As has been mentioned, it recognized life, liberty, and the pursuit of happiness as 3 unalienable rights. And it announced that governments, quote, derive their just powers from the consent of the governed. The Declaration's drafters thus viewed a government of limited powers as essential to safeguarding individual freedoms. One way of preserving liberty was through a decentralized government, one that acts via elected officials, not unelected judges. In the words of legal scholar Raoul Berger, an early originalist, the Declaration emphasizes that government is founded on the consent of the governed. The terms of that consent are spelled out in the Constitution. Substitution by the court of its own values choices for those embodied in the Constitution violates the basic principles of government by consent of the governed. Now, how did these principles fare during the FDR administration? President Roosevelt's New Deal sought to dramatically reshape the role of the federal government, moving it well beyond the limited purpose of protecting individual rights. In a nutshell, the New Deal sacrificed individual liberties in favor of government regulation, with the goal of redistributing wealth and income and massively expanding governmental reach in areas of employment, housing, and education. But before those efforts could be completed, the Supreme Court was asked to intervene and to limit the federal government's reach by, of all people, a farmer in Ohio. You may already know the story. The Agricultural Adjustment Act of 1938, a centerpiece of the New Deal, made price supports mandatory for certain crops to maintain a sufficient supply. The law also imposed quotas on farmers and producers to keep supply in line with demand. Roscoe Filburn, a farmer living outside of Dayton, was growing wheat to feed his animals. When Filburn grew more wheat than the per acreage amount permitted by the act, the Department of Agriculture ordered him to pay a penalty. He responded, as we do today, by filing suit in federal court, making an entirely reasonable argument. Congress, under its Commerce Clause authority, could regulate only interstate commerce. Yet Filburn's wheat never left his farm, meaning it never traveled interstate. And more fundamentally, the wheat was never sold, meaning it was not even commerce. Ultimately, the Supreme Court disagreed. In its groundbreaking 1942 decision, Wickard v. Filburn, the court held that even if Filburn's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. The Supreme Court decided that Filburn's wheat growing activity, while itself not substantial, if viewed in the aggregate through the lens of thousands of other farmers like Filburn, reduced the amount of wheat on the open market, which is substantial and thus fell within the Commerce Clause's scope. As numerous historians have observed, following Wickard, Congress's commerce power in effect became the national police power rejected by the framers. Going forward, Congress could use the commerce power to legislate for virtually any reason, allowing the federal government to achieve objectives otherwise obtainable through the Constitution's enumerated powers. That state of affairs evokes the Declaration's complaint that the king had, quote, erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. In many ways, the regulatory powers afforded Congress by the Supreme Court authorized the very same conduct, this time by our own federal regulators. Another tenet of the Declaration is its pronouncement that the colonies, quote, are and of right ought to be free and independent states. The Declaration called out the monarchy for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases. At bottom, the Declaration recognized the importance of self-governance at the state level. But courts can take away the authority of state legislatures by making rights flow from judges rather than voters. And that is exactly what happened in America in the 1950s and the 1960s. In a series of decisions, the Supreme Court and what came to be known as the Warren Court, reflecting the name of the then Chief Justice, interpreted the Constitution in a way that curbed a state's power to make decisions for its citizens, thereby reducing the citizens' right to self-governance. Those decisions spanned many areas of public life, from whether a state could allow prayer in public school to how states could apportion voters for legislative districts. Some of the most notable curtailments of state autonomy, however, arose in the criminal law area. One example is the 1961 decision in Mapp versus Ohio. Now, you might be sensing a theme here with my emphasis on cases from Ohio, where I reside. In Mapp, the Supreme Court addressed what had come to be known as the exclusionary rule, which the court had previously located in the Fourth Amendment's prohibition against unreasonable searches and seizures. Without a clear textual basis, the court held that the states were bound by the rule, which prevents a prosecutor from using evidence that was obtained in violation of the Fourth Amendment to convict a criminal defendant. Now, doing so limited the ability of states to make their own judgments as to law enforcement. As my colleague Chief Judge Jeff Sutton has noted in his book, 51 Imperfect Solutions, at the time of Mapp, about half the states had adopted an exclusionary rule, but the others had not. Rather than letting states continue to operate as labs of democracy, the Supreme Court federalized the rule, sweeping local autonomy to the side. Perhaps, like an English king, the majority justices, in the words of the Declaration, declared themselves invested with power to legislate for us in all cases. Now consider the 1962 case in Robinson versus California. At the time, California prosecutors, in pursuing drug offense convictions, often had ample evidence that a person habitually used drugs, but little evidence of any specific instance of use. So the state legislature expanded its misdemeanor drug use law to prohibit being, quote, addicted to drugs, meaning one could be convicted if the state proved beyond a reasonable doubt that the accused used drugs often or daily, even in the absence of any specific instance. Casting aside California's effort to plug a hole in its drug enforcement laws, the Supreme Court held that criminalizing the habitual use of drugs violated the Eighth Amendment's prohibition on cruel and unusual punishments. Now, previously, that prohibition had been taken literally as a ban on certain forms of punishment, say the guillotine. But in Robinson, the Supreme Court deployed the Eighth Amendment to govern what states may punish. In other words, states were now categorically barred from enacting certain criminal laws. Although criminal law is in many ways the ultimate reflection of a community's values, the Warren Court routinely nationalized the area by imposing constitutional limits upon what conduct a locality could criminalize. The signers of the Declaration, however, would surely have viewed state legislatures, not an activist court, as the proper defenders of liberty in America. After all, unlike court decisions, the judgments of elected officials enjoy the imprimatur of the consent of the citizenry. Now, up to now, I've highlighted ways in which the Supreme Court's practice of stripping the power of self-governance from the people violates the spirit, if not the letter, of the Declaration. But it does not follow that the Declaration encourages the people to retaliate by stripping power from the judiciary. An independent, neutral judiciary is essential to the Declaration's vision of limited government by the political body. Recall the Declaration's complaints that the king, quote, had obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers and has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. This objection arose from the ongoing struggle for judicial independence from the arbitrary executive of the will of the crown. Over the centuries, English common law judges pushed back on the crown's primacy, asserting their duty to follow the law above the will of the king. By 1701, this long struggle had resulted in an act of parliament guaranteeing judges tenure, quote, during good behavior, rather than at the pleasure of the monarch. In the colonies, however, King George maintained judicial tenure at his pleasure. The Declaration targeted this practice of allowing the king to rule the colonies by his arbitrary executive will. Echoing the Declaration, the Federalist Papers likewise emphasized the importance of judicial independence through life tenure. The Declaration, Federalist 78 noted, recognized that the people enjoy the right to alter or abolish the established Constitution. But this does not mean that the representatives of the people, whenever a momentary inclination happens to lay hold of a majority of their constituents, may do whatever they please, just as the king did before the Declaration. Rather, a system of government consistent with the Declaration requires an independent judiciary, with no danger of an improper compliance to the political branches. Yet the 20th century produced an episode in which the Declaration's promise of an independent judiciary came under attack through attempts to change the court's size for political reasons. This push for court packing, that is, the manipulation of the court's size primarily to change the ideological composition of the body, represented a sharp divergence from the Declaration's theme of limited government. In 1937, President Roosevelt, frustrated by certain court decisions invalidating his sweeping New Deal legislation as outside the powers of the federal government, proposed legislation that would add 1 seat to the court for every justice over the age of 70 who refused to retire. In effect, this would have taken the court from 9 to 15 justices. The utter lack of historical support doomed Roosevelt's court-packing plan. This is perhaps no surprise, given how fundamentally our nation has rejected threats to judicial independence since the Declaration first complained of King George's attacks. In many respects, Roosevelt's efforts were, at bottom, the same as those of the king, who sought to rule by will rather than law. In view of Judge's life tenure, the attack on judicial independence could not take the same form as that in England, where judges were removed at the king's pleasure. But the effort to remake the Supreme Court itself into a more subservient institution in the wake of an adverse ruling reflects exactly the same instinct for rule by executive fiat, one the Declaration squarely foreclosed. So I see my time is up. I have to say, in court, when your time is up, there's a very bright light, red light that shines, and the Coolidge Foundation is much more amicable about it. They have a small light that you all can't see, but it's flashing now, so I know my time is up. So let me just say this in closing. These 3 episodes, the Supreme Court's blessing of the expansion of Congress's national regulatory authority, the Warren Court's policy making at the expense of the states, and Roosevelt's attack on judicial independence each represent the same fundamental struggles captured in the Declaration. As we move towards the 250th anniversary of that beginning, it bears reminding that our nation's founding was at bottom the embrace of liberty, a fight that continues today. Thank you.
Thanks, Judge. That was great. Our final speaker today is Professor Bradley Watson. Brad is an associate professor of government at Hillsdale College's Van Andel Graduate School of Government, right here in Washington, D.C. He's one of America's leading scholars of political thought and the progressive movement. Today, Brad will speak about how progressives in academia have used their positions to cement progressive ideas into American historiography. Professor.
Thank you very much for that introduction, and to the Coolidge Foundation for inviting me. I'm very honored by this invitation. One of the things I'm not going to do today is something that Judge Jones alluded to. I'm often asked to speak on that is to say the intellectual origins of progressivism and how progressivism insinuated itself onto the courts, especially the Supreme Court. But I'm happy to speak about that in Q&A if anyone is interested. Instead, I want to talk to you a little bit, as the introduction hinted, at progressivism and the historians. I want to introduce you briefly to the extent to which leading 20th century American historians distorted and hid the nature of early progressive attacks on the principles of the Declaration and on the American founding more broadly. The historians did this not only by downplaying the progressives' hostility to the principle of equal natural rights contained in the Declaration, but also by downplaying progressivism's reconfiguration of Christianity to serve essentially secular progressive ends. So one of my claims is, thanks to the historians' dereliction of duty, as it were, these constitutional and religious dimensions of progressive thought have in effect remained cloaked for much of the past 100 years. And this shading and distortion have, of course, had an impact on the way American history has been taught now for many decades, from the universities to the things that are downstream from the universities, especially the K through 12 educational institutions in America. In 1863, Abraham Lincoln reminded his listeners that America was conceived in liberty and dedicated to the proposition that all men are created equal. Earlier, in his Lyceum address, he had proclaimed that all living Americans are the legal inheritors of the fundamental blessings bequeathed by the founders, whose principles, institutions, and very names we have a duty to preserve. Not because they're old or merely useful, although they are useful, Lincoln thought, but because they're true. They're true because they are in conformity with the cause of civil liberty and natural rights. They must shine on, as he said elsewhere, in naked, deathless splendor. I think the political rhetoric and actions of Lincoln remain among the greatest statements that there are such things as natural rights, that do not change with time, and that America, as evidenced in its founding declaration, is dedicated to preserving them. There are certain fixed principles beyond which progress is impossible, a proposition that, as others have noted here, Calvin Coolidge endorsed decades later. If all men are created equal, that is final. If they are endowed with inalienable rights, that is final. If governments derive their just powers from the consent of the governed, that is final. No advance, no progress can be made beyond these propositions. But elite American political thought, subsequent to Lincoln, has, with very few exceptions, amounted to an explicit attack on this old understanding of American constitutionalism. It's a large-scale attack missed, as I have said, by our leading historians. From the earliest days of the progressive intellectual revolution, commencing really in the late 19th century and through the early decades of the 20th century, we have seen this progressive attack in the form of a denial of human nature and therefore of natural rights, and an embrace of the idea that the arc of history is moving us and must move us away from our founding principles. And those progressive intellectual currents already also swirled, as I've suggested, around Christianity. Prior to the Progressive Revolution, American mainline churches still buttressed the constitutional order by linking human fallenness to the need for what? Political moderation and individual rights and responsibilities. Early progressives fully recognized that the regime change they wanted necessarily meant also religious change. and vice versa. They had to shake Christianity out of its original sin complacency. Early progressives argued for a reconstituted worldly Christianity, which called for the expansion of the state in the name of moral and political progress. By the first decades of the 20th century, you saw both Protestant social gospelers and Catholic reformers vigorously attempting to shift the center of gravity of mainline Christianity toward applying what they claimed to be a true Christian ethics in the here and now. The real presence of Christ comes to take on wholly new meaning. Early progressives understood this project to be quite radical. Progressive theorists, statesmen, theologians alike embraced a notion that material and spiritual fulfillment can be found in and through the good graces of the state. They rejected anything they saw as too individualistic, anything too oriented toward false conceptions of natural rights. Yet, as I've said, by the middle part of the 20th century, our leading historians of progressivism were reporting that it had essentially never existed. They tried to airbrush all of this from American history. I have time to mention just a few examples here, but some of you might know some of the names I'm going to mention. They are the authors of big fat books that lined the bookshelves of middle-class America from about the 1950s to the 1990s, and you might have some of these on your shelf, or you might have grown up in households where some of these were on the shelf. One of the leading public intellectuals and political historians of the last century was a fellow by the name of Richard Hofstadter, who was at Columbia University. He wrote a significant mid-20th century consensus view of American intellectual history. It was called The Age of Reform, written in 1955, and it de-emphasized the depth of philosophic disagreement that separated the progressives from the founders of the American regime. According to him, progressive thinking was simply the norm in America. This is common to a lot of these historians. He begins with a telling autobiographical observation. He says this: "The tradition of progressive reform is the one upon which I was reared and upon which my political sentiments were formed, as it is indeed the tradition of most intellectuals in America." And of course, that's still true today. Intellectuals remain blinded by their insularity. It's a disciplinary and reinforced by academic disciplines within the university, as well as a kind of, a sort of clubbishness across individuals. Hofstadter, in effect, describes the age of progressive reform as being so mild that it's easy to assimilate it to the main currents of American history. And in this account, populism merges with intellectual progressivism in a way that threatens essentially nothing. He says, "When the farmers and the gentlemen finally did coalesce in politics, they produced only the genial reforms of progressivism. The man on the white horse turned out to be just a graduate of the Harvard boxing squad, equipped with an immense bag of platitudes, quite willing to play the democratic game." And of course, this is a geniality that in Hofstadter's telling has no worthy opponent in American history. He insists America lacks a conservative intellectual tradition. So progressive thinking exists as a kind of highbrow reaction to mere crassness on the other side. Quoting Lionel Trilling, Hofstadter claims conservatives resort only to irritable mental gestures. You might have heard that phrase before. I have a lot of irritable mental gestures, as my wife will tell you, but I don't think they're due to my conservatism. Irritable mental gestures rather than ideas. Conservatives have simply, he says, been out of touch with the main lines of thought and with the primary public they would like to reach. Strikingly, the possibility of a genuine constitutional conservatism, one that stretches from the founders to Lincoln to William Howard Taft to Calvin Coolidge, is beyond Hofstadter's ken, and that is typical of the sort of big name mid-20th century historians. Or take another leading light of among 20th century American historians, Arthur Schlesinger Jr., who some of you might have heard of. He echoes the central theme of the progressives. He observes matter-of-factly that the problem remains of ordering society so that it will subdue the tendencies of industrial organization and produce a wide amount of basic satisfaction. If there's a threat to America, according to Schlesinger, it is the threat to the vital center of American politics. That's a vital center that he identifies with the New Deal, surprise, surprise. It's this center that has to hold in the face of enemies, both foreign and domestic. For Schlesinger, the right simply obsequiously, in his words, serves the business community by rejecting the progressivism of Teddy Roosevelt, amongst others. So our only hope really is with the progressive left, whose ideas must be put into practice. And how are they put into practice? via the New Deal. Schlesinger sees no constitutional or regime problems with this whatsoever. And I could mention more famous historians who emphasized only the purported continuities of the American political tradition rather than important disjunctions in thought, from Louis Hart's The Liberal Tradition in America to Henry Steele Commager, The American Mind, Daniel Boorstin, The Genius of American Politics. These are all mid-20th century important historical volumes. In their accounts, there was a peculiar mix, I think, of understatement and triumphalism about the kind of lack of fundamental, contest in American thought. And again, the progressives' own searing constitutional and theological critiques, which they themselves were shouting from the rooftops in the early decades of the 20th century, attract surprisingly little attention from our court historians, almost none. By the 1970s, in fact, one prominent historian went so far as to write what he called an obituary for progressivism and for attempts by scholars to chronicle a phantom. Progressivism, in his telling, had simply never existed as a coherent intellectual phenomenon. And as I've written elsewhere, it was as if scholarly ghostbusters for decades had placed their cameras in the haunted mansion of American history, only to come up with nothing, at least nothing clearly identifiable as progressivism, once the videotapes had been carefully scrutinized by the real technically adept experts. Let me conclude with something Winston Churchill is reputed to have said. It's always good to conclude or begin with Churchill. He said this: "History will be kind to me, for I intend to write it." Which of course he did. But if one looks at the course of American historiography over the 20th century, one sees that scholarly interpreters of progressivism were either its original intellectual architects in the beginning decades of the 20th century, or a generation or two later, they were in deep sympathy with both its premises and conclusions. And when history is told so incompletely, so tendentiously, so badly for so long at our so-called elite institutions, it comes to permeate everything. Our historical understandings are very much downstream from those who have written the history books for us. So nowadays, we're left with the need for a re-education in the nature of American principles, a re-education needed especially throughout the humanities, the social sciences, but also the legal fields. We could do a lot worse, I think, than look to Calvin Coolidge for inspiration in this effort. Unfortunately, I think there are signs that this re-education has started, and we can talk about that more in the Q&A if you like. Thank you.
Great. All right, I have a few questions, but I'm going to take a pass on those. Given our time, let's go straight to student questions. And don't forget that Judge Jones wants to talk about another case or two, so that's a little clue for what a good question would be. All right, questions.
Thank you to the panel. My name is Luke Pollack. I'm from the University of Alabama. I was intrigued by the interpretation by President Wilson of the Declaration of Independence that the panel talked about. And so what I wanted to ask could probably be answered in two aspects. What are the connections between interpretations of the Declaration of Independence and the more prevalent interpretations we see of the Constitution? And what are some interpretations of the Declaration of Independence in modern times that we see in our everyday lives?
Let me take a stab at that. To the extent we see interpretations of the Declaration, or you might say interpretations of America right now, they are misinterpretations largely stemming from, given fuel, given intellectual energy by the 1619 Project in particular, but those misinterpretations have been around for a long time, beginning with the Progressive Revolution, of which the 1619 Project is in a way the latest manifestation. In these interpretations, the idea that the American founders actually believed that there were such things as individual natural rights, this is tantamount to like a ghost story or something. I mean, they just don't believe it, or they don't even believe that nature, human nature, exists. Right? It's a rejection of human nature. If you reject a fixed human nature, you must reject the kind of political theory of natural rights. So the most common sort of middle-brow interpretations that we get right now are misinterpretations. It's not until the late 20th century that a group of political theorists, mostly meeting in the desert, on the edge of the desert in Southern California, in a place called Claremont, got together and started trying to understand the Founders' Constitution on its own terms and push back against some of this early progressive misinterpretation. And as I say, it's been given a kind of rocket fuel now because of very fashionable scholarly interpretation. So I think there's a lot of misinterpretation, but it has been for a very long time, and the pushback against it, interestingly, has come, historians hate me when I say this, it's come less from the historical profession and more from political theorists who try to understand the Founders' Constitution on its own terms. So the political, if you will, theorists of the American founding have been trying to correct the historical record because historians haven't been doing it. So I'll let anyone else add to that.
Hello, my name is Patrick Bernal. I'm from New Jersey, but I'm currently attending the University of Notre Dame for economics. My question is, you guys very eloquently laid out how the essentially theory of individual rights, of the natural inborn rights of the human being, was overtaken by the progressive idea of an arc of human history, of a future which we must strive towards. My question is, how and why did that happen? What made progressivism so compelling, at least in academia it seems, and while you do see lone figures like Calvin Coolidge really pushing back against it, what allowed them to so thoroughly and completely sweep our national consciousness and essentially write our understanding of that battle in a progressive manner?
Can I say a word?
Go for it.
Never let a crisis go to waste. And the progressives took advantage of the fact that there was a great deal of labor unrest and problems with the agricultural sector in the late 19th century. A lot of immigrants, a lot of low-wage labor as it was perceived, and people wanted to improve the conditions. You had what you called the then yellow dog journalists who promoted these crises in a very extravagant and dramatic way, just as the crisis of homelessness or the crisis of fentanyl are all, and I don't say those are not serious, but there are ways in which you can publicize. And the rhetoric got very strong, and then you have Woodrow Wilson expanding the reach of the administrative state, and then the crisis of the big crisis, of course, was the Depression.
Right.
And that was the motivating force. The progressives in the Democratic Party took over full control of the government for nearly, 20 years or more, and we were on a roll. So.
Anyone else?
I have a quick, sorry, go ahead. I have a quick answer to that, and I think one of the intellectual attractions of progressivism in the early going is attributable to the power of Darwinian ideas. Charles Darwin published his Origin of Species. The first edition was published, I think, in about 1859. It becomes a kind of touchstone for American political thinkers. Why is that so fascinating? They start applying Darwinian evolutionary categories not just to biological organisms, but to obviously to human beings themselves, but also therefore the creations of human beings, constitutions, political regimes, things like that. And they insist that everything is in a state of evolutionary flux, and what exists now is by definition more advanced, stronger than what existed beforehand. Why was that so attractive? Because in the late 19th century, the humanities and social sciences are fascinated by, they're trying to hitch their wagons to the star of natural science, and they think natural scientific concepts can and should be imported into everything. So with the foundation of the academic disciplines, the American Historical Association, the American Political Science Association, the modern American law schools in the early decades of the 20th century, they're all invented to be vehicles for this new progressive kind of evolutionary model applied to everything. It's just very, very attractive to intellectuals to think, we're like the natural scientists now. So that accounted for a lot of the intellectual attractiveness of it.
I'll just add a footnote to that is in the criminal area at the late 19th century, there was a theory that you could determine criminal behavior by the shape or size of the brain. and also it led necessarily to the eugenics movement. And the eugenics movement was popularized by what's-her-name Sanger, who was also a great racist. Eugenics was promoted to do away with inferiors, which led to Buck v. Bell and the promoting of abortion in minority communities.
Judge.
Just to tie the first two questions together from a judicial perspective, I think the Declaration was about liberty. I think that value was ingrained in the Constitution through the separation of powers, not only at the federal level, but then the balance of powers between the state and federal governments. And it's important for courts to keep those rules in mind, but we've seen episodes, especially in the 20th century, where judges, it's tempting to do, where judges sometimes maybe instilled their own values or their own worldview into how cases should be decided, as opposed to letting legislators do that kind of thing. And it can be a dangerous practice, because once a court, for example, interprets the Constitution, no state legislature, Congress can't undo that interpretation. And I tried to highlight some examples of where over the last century the courts maybe got out in front of what their traditional role. You know, the Federalist Papers envision the courts as being the least dangerous branch, and I think you could argue there are points in time where the court exceeded the traditional role it was understood to take. I want to hear from Congressman Cox, and I want to ask a question, which is Judge Jones, I wanted to hear about your case you were going to talk about, so maybe we can get to that.
I'll just punctuate on Woodrow Wilson and say that the premise of your question is that progressivism took America by storm, and it was this widely popular movement. In fact, Woodrow Wilson made progressivism ungreat again, because by the time he was finished, the election of 1920, that he himself declared a solemn referendum on his policies, turned out to be the greatest popular vote landslide defeat in 100 years. Wilson himself was fundamentally an elitist, and he redefined progressivism as rule by elites. That's really the only constant throughout his entire career, and that was not entirely popular. The nation was very much disrupted by all of the nationalizing of industry and so on that took place during World War I, which was very excessive and unnecessary to the war effort, hindered it in many respects. So I think you have to say that the Coolidge era that followed, was very much a popular revolt against progressivism as defined by Woodrow Wilson.
By popular demand, we'll go to Judge Jones's case, and then we'll have time for one more question. Judge.
Adkins v. Children's Hospital was a decision in 1923 that held that Congress, acting as governor for the District of Columbia, could not administratively regulate minimum wage for women. And the opinion, again, was subsequently overturned by Supreme Court in the 30s, the New Deal Supreme Court. But it elegantly explains the limits of what a legislature ought to do. And I urge you to read accounts of it by, among others, Professor Hadley Arcus. But again, a majority of the Supreme Court subscribed to the opinion that you have a right to contract. And for present purposes, I won't go through 6 reasons, well, I will go through 1 or 2 of them, why Justice Sutherland said this law makes no sense. One of them was the criterion for the minimum wage was to be determined based on different kinds of occupations, and it was to be determined based on what was the minimum wage that a working woman needed to protect her morals and supply her necessities of life. Well, various committees have decided that a laundress working in a laundry only needed $9 a week to protect her morals and supply the necessities, whereas a food server needed only, and it may have been a month, but $15 a week to preserve her morals and her necessities. One of the plaintiffs in the case was Miss Willie Lyons, who was an elevator operator at the Children's Hospital. She was regarded as a very good employee. She worked for $35 a month plus 2 meals a day. According to this committee, she was required to be paid $71 a month. Well, when she had lost through the administrative and lower courts, which meant that she got fired. Why? Because, of course, they replaced her with a man. Now, what's really interesting about this, aside from the fact that this was almost the last gasp of the Supreme Court using property rights as a fundamental right under the 14th Amendment, is that Justice Sutherland, who has been roundly condemned as a pariah ever since then, including by many judicial conservatives, also focused in his opinion on the fact that the 19th Amendment had recently been passed. Before he went on the bench, Justice Sutherland advocated quite a bit for passage of the women's right to vote. He said, look, there are many changes going on with women in society. Their status is being continually elevated. What's the point of this paternalistic legislation that assumes that a woman cannot contract on her own behalf? Well, the dissenters in that case, led by Justice Taft, were willing to dissent, but then Taft begs off and says, well, this is only true for women. In other words, men might be able to contract for their own minimum wage, but not women. And Justice Oliver Wendell Holmes, again, says it would take more than the 19th Amendment to convince him that there are no differences between men and women, and legislation cannot take those differences into account. So there you have a contrast between a traditional natural rights-based jurisprudence on the one hand, and the impact of legal realism, no limits to what the majority acting with unbridled concern can do.
Final question. Let's go in the middle right here. This woman, young woman right here.
Hi, I'm Sophia Lynn. I'm a senator from Arizona, and I had a question on property rights. Sorry. So specifically looking at Locke's labor theory of value, which essentially determines that like the value and property rights are based off the labor that is put into the land, or I guess it could be intellectual property. I feel like it's a little bit simplistic, but a lot of America's property rights are based off of that. So are there any like particular instances where you don't think that's applicable, or how it may even be problematic in our society?
How else are you going to decide what property is?
Well, I think it's a good foundation. I just think that it's not like entirely applicable.
The whole history of property law, from the Babylonians through the Bible, through Egypt, and everywhere else, is based on what a person produces or owns or inherits or acquires. Therefore, it is all based in reality. I'm not sure how else you determine what property is, and therefore how else you would conceive of regulating it. And the error that what many law schools do nowadays, instead of really teaching property, they will allude to real property, but what they're really teaching is property redistribution. And that starts with the idea that all property belongs to the government, or at the sufferance of the government, and is there to be given to other people according to airy notions of social justice. So I would say that you have to start off with what's real and concrete, and take property law in terms of that beginning.
I'll emphasize what Judge Jones just said. I think that the point of Locke's labor theory of value is to emphasize that property is a natural right. You know, your right to own and claim as your own, which means the right of exclusion of others, this is not something that is subject to the vicissitudes of government, ultimately. It is part of who you are as a person, almost as much as a part of your hands that add the value to the property, right? It's a direct extension of you as an individual, and therefore it is something that you can claim by nature, because he says you can claim it before there is government, right? The right to property, the labor theory of value, operates in the state of nature, so it pre-exists government.
Now that wasn't so bad, was it? Let's give a big round of applause for our panel.